ho! Merry Christmas! Welcome back to another episode of Lawyered Up. I am your host, Jared Moore. And on Lawyered Up, we will take your questions from the chat. You just got to remember, I myself am not a lawyer. So that's an important point. I know on our last episode, some people were asking in the question or the comments after the video was up, am I a lawyer? I am not a lawyer. Some of the other viewers pointed out to the person that I said that, but just keep that in mind, guys. I'm just like you. I'm a regular Joe. So today's program, we're going to be talking about the O'Brien decision that came out of the Oklahoma Criminal Appeals Court, or Criminal Court of Appeals. And but before we go into O'Brien, we're going to have an update on the Tlaloc Tribal Town versus MCN Judges case. If you don't know what I'm talking about, there is a link to our prior coverage on that case in the description of this video. And anything that I'm reading from today, there's also a link to a Google Drive in the description of this video, so you guys can go and download it and read it yourself or follow along while we're going through it. Okay, with that being said, I am going to pop up the documents and we'll start off with the Tlaloc Tribal Town case update. So if you guys remember the Tlaloc Tribal Town case, in our prior coverage we have the breakdown and the history of the case and also the oral arguments. So it's a long video, but if you guys want to go check that out, I'm not going to dwell on it too long, but I do want to point out what is the decision from those oral arguments. Got to go way down here. Way down here. Oh, too far. So conclusion. We hold the case is constitutionally moot because the Mvskoke courts have relinquished all jurisdiction over the town. Therefore, we vacate the district court's judgment and dismiss the case as moot. So, just so you guys know, that means the case got dismissed, and the MCN judges basically won their argument. Okay, so that wraps up that particular case for now. Let's move on to the O'Brien case. Okay, so this is the opinion that came out of the Court of Criminal Appeals for the state of Oklahoma. It was issued December 5th. I'm just going to start reading from the opinion, and then when I get to the point where I'm going to give my opinion on the judge's decision, it is important to remember that the Hooper case is also mentioned in this opinion because the rationales are similar and some of the arguments are similar. If you guys want to catch up on where the Hooper case is, you can look at our prior coverage. A link to that is also in the description of this video. And it is also important to remember, I'm going to read a statement from Chief Hill about this opinion later on after we get through with this. It's important to remember that at the federal level, the Creek Nation currently has a lawsuit against the City of Tulsa for their continued enforcement as opposed in defiance of court rulings. But we'll get to that when we get to Chief's statement. Okay, so the judge in this is Hudson, and he starts off with Nicholas Ryan O'Brien was charged in the Municipal Criminal Court of the City of Tulsa with the following misdemeanor traffic crimes: driving under the influence, transporting an open container, operating a motor vehicle with an expired tag, driving left of center, and improper use of left lane. This occurred on August 30th, 2021, while O'Brien was driving a motor vehicle in a multi-lane public street at or near 1300 South Denver Avenue in the City of Tulsa. This traffic stop was conducted by the Tulsa Police Department. On October 6, 2022, O'Brien, through counsel, filed a motion to dismiss, alleging that the city lacked jurisdiction over his case pursuant to McGirt versus Oklahoma, because he was an enrolled citizen of the federally recognized Osage Nation tribe. That's important to remember that he's not Creek. We'll get to that, though. And the alleged crimes occurred within the boundaries of the Mvskoke Creek Nation. In McGirt, the Supreme Court held that the Creek Reservation in eastern Oklahoma was never disestablished by Congress and thus constitutes Indian country for the purposes of federal criminal jurisdiction. The Honorable Mitchell M. McCoon, municipal judge, denied the motion on January 13, 2023, finding that the city had Finding the city had jurisdiction over the case, in his written order, Judge McCune cited a federal district court decision agreeing with Tulsa that Congress granted the city jurisdiction over municipal violations by all its inhabitants, including Indians, through Section 14 of the Curtis Act. On June 28, 2023, O'Brien's counsel filed a second motion to dismiss for lack of jurisdiction, this time based on the 10th Circuit's reversal in Hooper. In that decision, the 10th Circuit held that the Section 14 of the Curtis Act no longer grants Tulsa jurisdiction over municipal violations committed by Indians. Tulsa filed a response pleading opposing O'Brien's motion to dismiss. Tulsa maintained its previous arguments based on the Curtis Act. In the alternative, the city argued that the state of Oklahoma retained concurrent jurisdiction with the tribes over criminal offenses committed by Indians on the reservation, and thus Tulsa also had concurrent jurisdiction over Indian offenses as delegated by the state. Tulsa cited Oklahoma v. Castro Huerta to support its claim that there is no federal statute granting exclusive jurisdiction to the tribes or federal government over non-major crimes committed by Indians in Indian country. Tulsa invoked the balancing test from White Mountain Apache Tribe versus Bracker and argued that the balance of tribal interests, federal interests, and state interests does not bar the state and therefore the city from prosecuting O'Brien's crimes in its courts. Tulsa specifically argued that the exercise of concurrent state-delegated jurisdiction in O'Brien's case does not unlawfully infringe on tribal self-government. So that's the important thing there, that the argument is that it doesn't infringe on tribal self-government. On August 14th, 2023, Judge McCune conducted a telephonic conference with counsel for both parties and advised the parties for the first time that he was dismissing O'Brien's case for lack of subject matter jurisdiction. The court advised that a written order would follow. Counsel for City of Tulsa at that time advised the city would be appealing the court's decision as a reserved question of law concerning subject matter jurisdiction. On August 17, 2023, Judge McCune granted O'Brien's motion to dismiss in a written order. Judge McCune found that the 10th Circuit decision in Hooper undermined the city's arguments based on the Curtis Act and that it, quote, must follow the law that is in place at this time, end quote. Judge McCune also rejected Tulsa's alternative argument based on Castro Huerta as follows. And they're quoting the judge. The city of Tulsa asserts that Oklahoma v. Castro Huerta confers concurrent jurisdiction to the city for violations of ordinances in the city of Tulsa. However, the Castro Huerta ruling is specifically limited to concurrent jurisdiction to prosecute crimes committed by non-Indians against Indians in Indian country. No mention is made as to concurrent jurisdiction when the defendant is Indian, nor does there appear to be any discussion in Castro Huerta that the General Crimes Act confers concurrent jurisdiction over defendants who are Indian. I just want to pop in here real quick. So the Castro Huerta decision said that basically the state can prosecute non-Indian offenders who commit crimes against natives on the reservation. And that was also the status quo before that decision was made. That's the way it's been for a long time, is that tribal governments and tribal courts very rarely, if ever, have the ability to prosecute non-Indians in their courts. There's some stuff carved out in VAWA, but for most things, especially DUI and things, you couldn't bring non-citizens or non-Indians into a tribal court on those charges anyway. So that wasn't a big revelation. Now I'm going to continue on here. The city of Tulsa now appeals this ruling pursuant to yada yada yada. Below, we address the merits of the appellee's motion to dismiss Tulsa's appeal for lack of jurisdiction and then address the merits of the city's substantive claims. Okay, I'm going to scroll down here a little bit and get to the part that is the meat and potatoes of this decision. Here we go. We further find this appeal is authorized under the plain language of Section 1053(7), which authorizes a state or municipal appeal upon an order, decision, or judgment finding that the defendant is immune from or not subject to criminal prosecution. Judge McCune's order dismissing this criminal case found that the appellee was not subject to criminal prosecution based on his Indian status and the situs of the crime on the Mvskoke Creek Reservation. The language of Section 1053 does not limit this provision to stand-your-ground appeals. Based on the foregoing, O'Brien's motion to dismiss this appeal for lack of jurisdiction is denied. Now I'm going to scroll down here a little bit. I want to go past the get to the part that's here we go. Let me go up here a little bit. In Castro Huerta, the Supreme Court recognized that the Constitution allows a state to exercise jurisdiction in Indian country. Indian country is part of the state and not separate from the state. Indian reservations are no longer viewed as distinct nations like in the past. Unless preempted by federal law as a matter of state sovereignty, a state has jurisdiction over all its territory, including Indian territory. This rule is based on the proposition that a state is generally entitled to the sovereignty and jurisdiction over all the territory within her limits. The Supreme Court recognized in Castro Huerta that since the latter half of the 1800s, the court has consistently and explicitly held that Indian reservations are part of the surrounding state and subject to the state's jurisdiction except as forbidden by federal law. Due to their incorporation into the United States, let me skip this part. This is just talking about the tribal sovereignty. I want to get to the part where they discuss the citizenship of O'Brien is not Mvskoke. Here we go. This is it. So, Indian reservations are part of the territory of the United States, and they hold and occupy with the assent of the United States and under their authority. Tribes nonetheless have the inherent power to regulate their own members and internal affairs through tribal self-government. This includes the inherent authority to, quote, to prescribe laws applicable to tribe members and to enforce those laws by criminal sanctions. Under the Supreme Court's precedent, a state's jurisdiction in Indian country may be preempted by federal law under ordinary principles of federal preemption, or when the exercise of state jurisdiction would unlawfully infringe on tribal self-government. So I don't know if you guys can see where he's going with this, but basically what the judge is going to say is this guy O'Brien is an Osage. He's not Creek. So if we prosecute him, right, it's not going to affect the Creek Nation's ability to govern its own citizens, right? Now, some people may be saying, "Oh, that's a good argument." I'm going to point out a problem with that when I get done reading this, but let's go back into it. I'm going to finish up here, hopefully. O'Brien's crimes are general crimes for the purposes of federal Indian law. The General Crimes Act borrows the body of federal criminal law that applies in federal enclaves and extends it to Indian country. However, nothing in the plain language of the General Crimes Act preempts the state authority to prosecute Indian crimes in Indian country. As the Supreme Court held in Castro Huerta, the General Crimes Act does not treat Indian country as the equivalent of a federal enclave for jurisdictional purposes, nor does the act make federal jurisdiction exclusive or preempt state law in Indian country. Both the federal government and the state have concurrent jurisdiction to prosecute crimes committed in Indian country. O'Brien and the amicus, the Mvskoke Creek Nation tribe, both contend that Castro Huerta does not apply here because that decision was limited to deciding whether the state had concurrent jurisdiction with the federal government to prosecute a non-Indian for a reservation crime against an Indian victim. To the contrary, the Supreme Court's discussion in Castro Horta about the ways in which a state's criminal jurisdiction over Indians may be preempted was not limited to criminal cases involving non-Indian defendants and Indian victims. The same is true of the court's interpretation in Castro Horta of the plain language of the General Crimes Act, which cannot logically be read to preempt state jurisdiction over Indian defendants, while not preempting state jurisdiction over Indian victims. In Castro Horta, the court observed that, to the extent that a state lacks prosecutorial authority over crimes committed by Indians in Indian country, a question not before us, that would not be a result of the General Crimes Act. Instead, it would be a result of a separate principle of federal law that precludes state interference with tribal self-government. Now, there's a section here you can see he talks about Public Law 280 and Oklahoma Enabling Act, and they kind of brush those aside. Oklahoma, just so everybody knows, isn't a Public Law 280 state, so it wouldn't apply anyway, but those are arguments that were made. Indian Civil Rights Act argument was made. I'm going to read that just so you guys get an idea of an argument that was put forward. O'Brien's reliance upon Congress's amendment to the Indian Civil Rights Act, recognizing the inherent power of Indian tribes to exercise criminal jurisdiction over all Indians, does not undermine the state's or the city's jurisdiction in this case. This amendment occurred after the Supreme Court's decision in Duro versus Reyna, holding that the retained sovereignty of a tribe to govern its own affairs does not include the authority to prosecute a non-member Indian for crimes committed on its reservation. The Supreme Court subsequently recognized this amendment does not interfere with the power or authority of any state. Nor does the plain language of Section 1301 make an Indian tribe's prosecution authority over non-member Indians exclusive. There's a 10th Amendment discussion here. I'm not going to get into that because I don't. I'm going to try to go down here and get to the main closing argument of the opinion here. And if you guys want to read it all, it's pretty long, but it is interesting. They talk about limited tribal sovereign immunity. Here we go. To summarize, the text of the General Crimes Act does not make federal jurisdiction exclusive or preempt state jurisdiction, language that preempts states' civil or criminal jurisdiction. Castro Horta. Precedents. The default is that states may exercise criminal jurisdiction within their territory. States do not need a permission slip from Congress to exercise their sovereign authority. The default is that states have criminal jurisdiction in Indian country unless jurisdiction is preempted. O'Brien's and the tribe's view that the state may only act if Congress specifically provides for it is inconsistent with the Constitution's structure, the state's inherent sovereignty, and the Supreme Court's precedents. We therefore reject O'Brien's and the tribe's claim that Oklahoma's criminal jurisdiction, and thus the City of Tulsa's criminal jurisdiction, is preempted because Congress has not expressly authorized it. Now they're going to go through the balancing question, and I'm going to scroll down here and start here. As in Bracker, this requires a balancing of federal, state, and tribal interests. Principles of tribal self-government do not bar Tulsa from prosecuting misdemeanor traffic crimes committed by non-member Indians on the Mvskoke Creek Reservation when those offenses occur on public roads and streets in the city of Tulsa. First, the exercise of state and municipal jurisdiction under these circumstances would not infringe on tribal self-government. Tulsa's prosecution of non-member Indians of the Mvskoke Creek tribe for misdemeanor traffic offenses occurring on public streets and roads in Tulsa does not affect the tribe's authority to regulate its own citizens for violations of Creek tribal law. In fact, such a prosecution would not involve prosecuting any citizen of the Mvskoke Creek tribe. Further, the City of Tulsa's jurisdiction would be concurrent. Hold on. I just want to point out there, you can see what they're going at. In fact, such a prosecution would not involve prosecuting any citizen of the Mvskoke Creek tribe. Further, the City of Tulsa's jurisdiction would be concurrent only and would not displace or diminish the tribe's prosecutorial authority to try Indians for violations of local tribal law. Tulsa's persecution of non-member Indians would bolster the tribe's strong interest in public safety for its citizens in this part of the Creek Reservation. To the extent that Tulsa's exercise of concurrent jurisdiction over non-Creek Indians for misdemeanor traffic offenses committed on the Creek Reservation would somehow pose a problem, Congress can seek to alter it. Second, Tulsa's prosecution of non-member Indians for misdemeanor traffic crimes also would not harm the federal interest in protecting Indians on the Creek Reservation. Federal jurisdiction over such crimes would be concurrent to the city's jurisdiction and thus not affected. The federal interest in public safety on the reservation for all citizens would be enhanced by Tulsa's assertion of jurisdiction over non-member Indians for these crimes. Okay, you guys get the idea. I'm going to go on down here and wrap it up. They discussed the Curtis Act, but we talked all about that in Hooper. So what happened? The appellee's motion to dismiss this appeal for lack of jurisdiction is denied. So they're saying that the court does have jurisdiction. The order of the Municipal Criminal Court of the City of Tulsa dismissing this case is reversed and remanded for reinstatement of the case and further proceedings not inconsistent with this opinion. So it's going back to the municipal court. Appellee's motion to strike the City of Tulsa's reply brief is denied. Mvskoke Creek Nation's request for oral argument is denied. Mandate is ordered, issued upon delivery and filing of this decision. Okay. So did you guys catch that? Does it make any sense? I see T.Y. Pearl's making some comments there. I'm going to get to you, T.Y., in just a second. I still want to give Chief Hill and read his statement that he issued when this decision came out before I talk about my personal problems with the opinion. So let's go here, and I'm going to pop up. If you guys want to check this out, this is on Chief Hill's Facebook. Principal Chief David Hill's statement regarding today's ruling from OCCA and City of Tulsa versus O'Brien. We've come to expect politically motivated decisions from this court, and today's ruling is no exception. However, this issue ultimately hinges on federal law, not state court interpretations. Our federal case against the City of Tulsa remains ongoing, and we are confident that the federal judiciary will bring clarity and adherence to the rule of law in this matter. Federal law clearly protects tribal sovereignty and defines jurisdictional boundaries, and we believe this ruling misinterprets the principles established under Castro Huerta. We remain steadfast in our commitment to defending tribal rights and ensuring justice is served in appropriate legal venues. This is about more than just one case. It's about preserving the inherent right of tribal nations to protect and ensure safety for everyone within their borders, where the exercise of state and local jurisdiction comes in the form of cooperation, not unlawful usurpation. We look forward to resolving this matter in the federal courts, where we are confident justice will prevail. Okay, so I'm going to recap what's happened. The opinion of the court, the Oklahoma Criminal Court of Appeals, hinges on the fact that O'Brien is an Osage. And so they're saying that, hey, because this guy is an Osage, he's not a Creek, the Creeks can't charge him. We have jurisdiction over him too, right? Like they're trying to split those hairs now. Here's the problem that I have with that first part. You can make an argument on the opposite side, right? So the judge is saying we have the City of Tulsa through the state has jurisdiction over O'Brien because he's an Osage. But what they're doing is, you could also say that they're stripping him of his identifier as a Native American from the federal government standpoint, right? He's going to be treated just like a non-citizen of any tribal nation, right? They're going to have jurisdiction over him too, and they're trying to whittle it down to just the Creeks. And it may seem like a small point, but if you look at the big picture of what's happening with, for instance, these taxes and stuff, or not the taxes, the fines and fees that are levied in these DUI charges and stuff, the Creek Nation has that code. They have DUI code here, and those fines and things would come to the tribe first, not the City of Tulsa. Why would that make any difference? Well, because the city of Tulsa may be incentivized to police in a certain way if they know that they can police non-Creek citizens, non-Creek Indians, and it's going to cause a kerfuffle. So that's the first thing. The other thing is, if tribal nations who are operating their jurisdiction, in this case the Creek Nation, aren't able to prosecute or have the first go if they're with their code on native members of federally recognized Indian tribes in the city of Tulsa, it's just going to try to reverse everything that's already happened, and it doesn't make any sense how the jurisdiction isn't being preempted for one. The federal government doesn't see tribal citizens as separate entities, right? If that makes any sense. The other problem that I have is it seems like you could easily make an argument in this case to say, hey, I'm not getting. O'Brien could make an argument saying, and I think he kind of does with the Indian Welfare Act or the Indian Rights Act, to say, hey, I'm not getting my due as a Native American in this situation. But it's going to go back to the municipal court, and it's going to get heard again. The jurisdiction part, the Curtis Act, is done. Not that they're never going to be able to use that again, but they are trying to use delegated state authority, which is just as, rocky a proposition. Okay, let me take a look at these comments here. Please explain the difference between cases in federal court as opposed to state courts. Will Mvskoke Media be seeking an interview with Tulsa Mayor Monroe Nichols anytime soon? As far as the interview with Monroe Nichols, I would love to interview him. I would just like to see something. I would like to see a motion first in court by the city of Tulsa to either get rid of their challenge against the Hooper decision, or I would like to see them do something, because right now I could have an interview with him and I could say, hey, are you guys going to do that? And he could say yes, no, or whatever he wants. No paperwork's been filed in the law. Whereas if they file something, a motion, then I can say, hey, since you have taken office, or since you were elected, this motion has been filed. Did you have any hand in it? Were you consulted in it? And that type of thing, to try to see where he stands on. Will you please consider doing a what is video explaining what the Porch Bandit Creek Indians are and the history of how they came to be recognized federally as a tribe? Read the Ogiabova case. We can do that. I am currently working on a long-form documentary about that whole issue because it's been going on for so long. And that would be bundled into that. So we are working on that, and we're going to try to put out something that's going to be, feature length about that case and the porch band and the issues with Hickory Ground. Is it normal to deny oral arguments in such an important case? Seems like an unusually extraordinary action outside of normal protocols. I think that this is just my feeling from reading the decision. I think that the reason oral arguments were denied is because the judge was like, oh, I know what arguments you guys are going to make, and I'm not having any of it. If we go and we go back up, hold on just a second, and we look at how he addresses some of these things, is kind of just brushing these issues to the side and saying, no, we need to focus on the fact that he's not Creek, and thus it's not affecting the operation of tribal government. Which to me, like I said, I don't know why it would matter if you're tribal government and you're tasked with enforcing tribal laws on citizens that are a member of a federally recognized Indian tribe, then I don't know how it's not how is it not impacting tribal sovereignty if you're not allowed to do that. That argument, I'm sure I guess it makes sense to the judge, but to me, I'm like, you're saying that it doesn't because he's not a citizen, but this is the designation between what would be concurrent federal jurisdiction or preemptive federal jurisdiction or preemptive tribal jurisdiction and concurrent tribal jurisdiction. They don't even have an agreement as far as I know, with the Creek Nation to do that, is this still Indian country? Yes, it is Indian country for the purposes of the General Crimes Act. So, but this is, they're trying to whittle it apart and split the hairs as much as they can. If they can get a conviction in a municipal court, if we look at what happened with the Hooper case, Hooper went ahead and paid his fine in the municipal court and all that stuff, and then it got challenged and it went up the food chain, right? So there were municipal decisions that could be heard. And we're still in the early days on the O'Brien thing because the judge at the municipal level reversed because of the 10th Circuit decision and said, we don't have jurisdiction. And then now the criminal appeals court is saying, you do have jurisdiction, hear the case. So there's still plenty of time for this to go up. And some of these things that I'm pointing out could get addressed, and maybe some new arguments could get proposed on either side. Tribes prosecute Indians in Indian country. That's how it's always been. Indeed. And why, though, right? Why is that the case? Because tribal governments inherently have a different set of priorities when they're prosecuting their own citizens or citizens of another tribal nation as opposed to non-tribal citizens. You see what I mean? City of Tulsa, or if we look at the definition on the federal government side of tribal nations as political groups and entities, okay? So a citizen of Tulsa that's not a tribal member doesn't have any political access to the tribal government system or anything else. And they're making the argument that an Osage citizen also doesn't have access to the Creek Nation's political system. But the Osage member does have access to the Osage Nation's political system, and the Osage Nation's political system works with the Mvskoke Creek Nation's political system in tandem to get certain issues and things addressed with the federal government and the state government. So to say they're totally not related, though, I think is, in my opinion, is disingenuous. It's not real. This is a state, not a federal court decision, correct? You are correct. This decision is from the Oklahoma Criminal Court of Appeals. That is a state court, and the decision is remanding the case back to the Tulsa City Municipal Court. So it's just the municipal court in Tulsa, right? Okay, I think we've covered all the bases on this. Again, if you guys want to go even deeper into this, you can read the decision. There's a link in the description that has the decision in this and the TTT case. Next week, I have a live wire scheduled on the 16th at 6 p.m. with Micah McDermott. He is a Mvskoke author who has written a lovely children's book that's for sale on Amazon. So if you want to tune in there and hear from him about his book and take a look at it, and maybe, stocking stuffer, if you want to spend some money with another citizen and support the culture, because the children's book is Ngosi's Saturday Adventure, I think is the name of it. So it has language in it and culture in the book too, is good. And then I'm working on maybe having another lawyered up on the 18th we're going to talk about CDIB cards, where they come from and what they are and what the rules are that apply to them, which may sound boring. But I promise you, if that show gets scheduled, it's going to blow your mind. You'll be like, what? And I don't want to ruin it too much, and I'm going to have someone who is with the Navajo AG's office come on to talk about that, who's written a paper about it. But I'm still scheduling with them. I haven't confirmed that. Otherwise, thanks so much for tuning in today, guys, and I will see you next week. Mado Hadum Chihichat Lees.